Thank you.
We are back on the record at 11:05 a.m.
All right, Mr. Howell, you may proceed.
Thank you very much. So, Ms. Kouemo, I'm now going to back to board tab 33, and I'm going to be looking at pages 34 and 35. Really more at 35.
Yes.
Okay, so this is an email you wrote to Erica Rivera, right?
Yes.
And this was also leave for which you didn't seek pre-approval, isn't that right?
Yes.
And this was after you had already talked to Mr. Martin about how annual leave worked, correct?
I don't think so. I believe that I talked to him the same day.
Okay.
And then in our conversation, no, I'm sorry. I had two conversations with Mr. Martin. So there was one before about the one that we talked about right before the break, and then the other one, yes, regarding. So yes, I remember that.
Okay.
Yes, it was after my first conversation with Mr. Martin about LWOP, annual leave, and taking lunch time, walking through lunch.
Okay. And you did, in fact, appeal the AWOL determination to Mr. Bruce Chung and to Mr. Rob Goodson, correct?
Yes, and assisted their directors also of the case.
Okay. I'm moving right along in this board tab 33, so it's going to be pages 37 to 45. All right. If we go to page 38, that towards the bottom of 38, that's an email that you sent to Mr. Chung, isn't it?
Yes.
Okay. And nowhere in that email do you deny that you failed to request leave beforehand, do you?
No, I did not.
Okay. You also didn't provide an explanation to Mr. Martin for what your personal emergency was on July 17th. Isn't that right?
I did not elaborate on what my personal emergency was, but I did mention that I had a personal emergency.
Okay. And if we go up to his response on page 37 of board tab 33, it's his second paragraph. There's a sentence that starts finally. Do you see that?
Finally on 7/17.
Yes. He says, finally on 7/17, and again without prior notice and approval, you were 2 hours late to a personal emergency, due to a personal emergency, but did not provide anything to substantiate your claim of a personal emergency. So he noted that you didn't provide that explanation, correct? An elaboration, I believe, as you described it.
Yes, he did.
And you still didn't provide him that elaboration, correct?
No, I did not.
Okay. We go to pages 46 and 47 of board tab 33. I apologize, it's actually going to be 47 through 56. Are you on page 47, ma'am?
Yes.
Okay. And 47, this is Mr. Goodson's denial of, this is the bottom of page 47, I apologize. This is Mr. Goodson's denial of of reversing the AWOL charge, isn't it?
Yes.
Okay. You also never told Mr. Goodson what the personal emergency was either, did you?
I did not elaborate on that, no.
Okay. We go down, it's on page 48. Do you see where it's another email from you to Mr. Chung?
Yes.
And actually, I'm going to be going to page 49. It's towards the end of this email. It's about halfway down page 49, and it starts, even the 1 hour phone call.
Yes.
You say, even the 1 hour phone call discussing SBA matters shows a desire to learn and grow, and I'm having a hard time believing that even that is considered being AWOL. Surely I thought it would be understandable that an attorney that has been doing pure data entry for 2 or 3 weeks, entering data on a spreadsheet, would feel the need to use one's mind and intellect, even if that means calling another office and request a leave to discuss work-related and SBA-related matters. Did I read that paragraph correctly?
Yes, you did.
Okay, so is it correct then that you thought it was within your purview to decide what tasks you wanted to complete?
No.
And you refer to the data entry, you refer to it as data entry. So once again, weren't you saying that the work was not, was beneath you as an attorney?
It was data entry.
I understand that. And were you contending here that it was beneath you as an attorney?
What I'm saying here is that it's understandable that somebody that has been doing data entry for a long time, that has been trained as an attorney, will find it mind-numbing to only do that for so long. That's what I'm saying here.
But you didn't think attorneys should ever have to do data entry, right?
I specifically stayed for 2 or 3 weeks entering data on the spreadsheet will feel the need to use both mind and intellect.
In other words, it's fair to say you wanted to do what you wanted to do, correct?
No, it's not fair to say that.
Okay. So moving forward, you have no direct evidence, do you, that Mr. Martin knew of your disclosure about rule changes to idle regulations, right?
No, like I said before, I tried to obtain that evidence through discovery. I wasn't able to get it. However, I have circumstantial evidence because as my supervisor, he also had access to my emails and MS Teams chat, and also as part of management, I believe that if somebody in the office management was concerned about whistleblower, that they will share that information with other people. Okay,
but you don't have any evidence, do you, that Mr. Martin actually knew about it? That's what I'm asking.
I do have evidence, circumstantial evidence, because of the way that I've been treated after I made the disclosures, and because of my performance plan, specifically saying that my supervisors or the managers had to evaluate my work by review. Our work as attorneys in the accounts department by reviewing communications with the borrowers and with with the staff at the office.
You don't have any evidence, do you, that Mr. Chung knew about those alleged disclosures either, correct?
That's pretty much this. Basically, I don't have any direct evidence, but I have circumstantial evidence based on the fact that being above my supervisors, if one of them was concerned about the whistleblower, they would probably share the information about the whistleblower.
I'll ask you the same thing about Mr. Goodson. You don't have any evidence that he knew about it, right?
I'm going to provide the same answer that I did for this question.
And that's that you don't have direct evidence, but you have circumstantial evidence?
Yes. And based on the fact that I don't have any direct evidence because I wasn't able to obtain it through discovery, but because he's manager and because of the events that happened after I made the disclosures, I believe that he knew about.
So those are just events that you're connecting in your mind, right?
Those are events that I'm connecting based on the way things happened and on the things that happened and the way things happened and on the information that I have.
It's correct, though, isn't it, that you just suspect that all of those individuals knew about the disclosure. You don't actually know that they knew about it, right?
I believe that it's more than just suspicion. That the facts back my that the facts.
Very well. All right. So in about August of 2020, you transferred to Ms. Jessica McCall's team, isn't that right?
Yes.
That would have been on about August the 10th of 2020?
That was my last week at the SBA, so it could have been, yes.
Somewhere around then?
Exactly.
It's correct, isn't it, that you only served on Ms. McCall's team for about 5 days, right?
Yes, 5 days, or yes, 4 or 5 days, I believe.
Okay, and Ms. McCall was just a team lead too, right?
She was a team lead. I don't want to say just.
Well, she wasn't a supervisor, was she?
No, she was not a supervisor.
All right, and so my understanding is, based on your testimony, you allege that you engaged in whistleblowing when you asked about the agency's use of a particular version of IRS Form 4506T. That is the use of the March 29, 2019 form instead of the June 2019 form, right?
Yes.
Okay. Can we look, please, at it's board tab 33. It's going to be page 59 of that.
Yes.
All right. And is this a conversation that you've seen before?
Yes. You provided it during the discovery process.
This is the conversation in which you asked Ms. McCall the questions about Form 4506T, right?
Yes.
So it's correct, isn't it, as you read this conversation, you never specifically told her that there was anything wrong with using the March 2019 form, right?
I did. When I said there is a new transcript format that better protects taxpayer data, this new format partially masks personally identified information.
Well, my question is, you're just providing information there. You're not specifically telling her there's something wrong with the the March 2019 version, right?
Well, that information does state that there's something deficient with that other version of the form.
Okay. And it's correct, isn't it? And Ms. McCall didn't criticize you for asking that question?
No, she did not.
In fact, she also agreed to forward the questions to management, didn't she?
She did.
And the quote that you send to Ms. McCall, did that come from the IRS website?
Yes, I said this is an excerpt from the IRS website, and I copied and pasted.
Are you aware that the IRS requested the SBA use that version?
Which version?
The March 2019 version.
If I'm aware that the SBA, that the IRS recommended that the SBA use that older version?
Yes, are you aware of that?
No, and the agency, I don't know if the agency has provided any documents showing that the IRS.
Okay. In this conversation, it's correct, isn't it, that Ms. McCall agreed to forward your questions to management?
Yes, she did.
Okay. So moving along in board tab 33, I'm going to be going to pages 61 to 65. Now you'll see eventually these emails get forwarded to you on page 61. But for a moment, I'm going down to page 63. Please let me know when you're there. Ms. Kouemo?
Yes, please.
Are you on page 63 of board tab 33?
Yes.
Okay. You see it's an email from Jessica McCall to Jennifer Davis on August 14th at 12:16 p.m.
12:16 p.m., yes.
And those are, in that email then, and I realize you're not copied on it, Ms. McCall forwards the questions that you asked her to Jennifer Davis, correct?
Yes.
And Jennifer Davis was in management, wasn't she?
Jennifer Davis, as I understood it, was somebody that was either above the team leads and then below the supervisors. So someone.
Okay. But Ms. McCall forwards your questions verbatim, doesn't she?
Yes, I believe she did. Yes, it looks like she did.
And then as we scroll up through the emails, we go to page 62. Several people weigh in on the answer, don't they, including Jennifer Davis and Chris Martin?
Yes.
Okay, and in those emails, nobody criticizes you for asking those questions, do they?
Not in those emails, no.
Okay, and that's my question. Not in those emails, nobody criticizes you, right?
Yes.
Okay, that includes Mr. Martin then, right?
Yes.
So as we go to page 61, Ms. McCall then provided you all of these emails, correct?
Yes.
And it answered your question about which version of the form to use, didn't it?
Yes.
And you just didn't like the explanation that it gave, correct?
I'm sorry, I'm not sure I understand the...
You did not agree with the explanation it gave. Is that true?
It's not that I didn't agree. The explanation didn't answer. The discussions that were forwarded to me didn't answer all my questions, or they didn't answer them truly.
All right, I'll put it different then. You didn't find the answer to be sufficient, correct?
Yes, I found the answers to be insufficient. And also, yes, not good management because they didn't really seem to address the P2 issue.
And P2, what do you mean by a P2 issue?
I'm sorry, privately identifiable information.
So PII.
Yes, I'm sorry, yes, PII. Sorry.
Just wanted to make sure I wasn't misunderstanding something. And Ms. McCall told you that loan processing would handle any issues about fraud, didn't she?
Yes, she did.
Okay. You never told anyone at the agency that the use of the March 2019 form violated a law, did you?
Since I did not use that specific language, but because Mrs. McCall, Mr. Martin, at least the email chain were attorneys, I believe that they understood that there was a law there that was being violated.
And what law did you allege that it violated?
Privacy Act.
The Privacy Act. But you can you state how it violated the Privacy Act?
By exposing private information, the customer's private information when it should be protected, or it could be protected.
But you never specifically told anyone it violated the Privacy Act, right?
No, and I also believe that it violated just attorney ethics, and maybe even managerial ethics. So,
all right, you believe it violated attorney ethics. Did you tell anyone that it violated attorney ethics?
No, I believe that to become an attorney, you have to take an ethics class. So,
did you cite a specific rule, such as from the ABA or the State Bar of Texas, that it violated?
No, but I believe that as attorneys, you have to take continuing education classes, and you basically, as attorneys and as people in management, they should know about those things.
Okay. If we're moving right along in board tab 33, it's going to be pages 67 to 70. I'm going to be looking specifically at the bottom of page 67 and the top of page 68.
Okay.
All right. And in this email, and you can take a moment to read it if you need, but you state in this email, don't you, to Ms. McCall, that you provided a borrower with both versions of the form. That is March 2019 and the June 2019 version, right?
Yes.
And you did that even though that you'd been told to use the March 2019 version, right?
Well, that included the March 2019 version.
But you also provided the June 2019 version, didn't you?
I did, but that was also while Mrs. McCall was consulting with management as to which form to use. So there wasn't too much clarity about which form to use, and I was hired as an attorney, so I used my best judgment to explain the difference to the applicant.
In other words, you took it upon yourself to provide him that option, right?
I believe that I was doing my duty as an attorney.
Even though you had been directed to use the March 2019 version?
Even though I had been directed originally to use the March 2019 version, but based on Mrs. McCall's answers after my inquiries, there was a question mark as to whether there was clarity on management side as to which version to use.
But you nonetheless had to go back to the borrower and correct what you had stated, right?
I did, yes. After she confirmed that management did not want the March 19 version.
You've also alleged in this case, I believe you testified to it earlier, that while you resigned, the resignation was involuntary, right?
Yes.
In fact, I believe you testified earlier that it was due to trauma that you endured by the agency?
Yes, I believe that the events that happened while I was working at the agency, and also the last event of the 45 or 60 from all those things played a role into my final decision.
But for example, you admitted earlier that for the various times that you were charged AWOL, you didn't have pre-approved leave, right?
For the various times that I was charged AWOL, no, I did not have pre-approved leave, but I believe that I'm following procedure based on this.
And you never did reveal the personal emergency was looking for another job, correct?
No, it was a personal emergency, and I did not want to elaborate on that because it was personal to me.
All All right, let's look at board tab. This is 23 this time. It'll be pages 235 to 237.
Okay.
Okay, towards the bottom of 236 and on to 237, this is an email that you sent on Saturday, August 15, 2020, 12:59 p.m., correct?
Yes.
That's the email in which you resign, right?
Yes.
In that email, you never said that you were forced to resign, isn't that right?
No, I did not want to. No, because I just at that time I just want to put it all behind me. So I just want a commitment plan and my documents and move on to better life.
So you also thanked the agency for the opportunity to do the work, didn't you?
Yes, yes, and I did that because that's the standard. I believe that's how you should resign from a position.
Okay.
Try and be in good terms.
So you sent the email at 12:59 p.m. Correct?
Yes.
And it was effective immediately then.
I believe I stated that it was.
Okay. And so there was no prior notice of your resignation?
No.
Okay. Now you testified earlier about your ethical duties as an attorney, didn't you?
I did.
Is it consistent with your ethical duties as an attorney to quit a job with no notice?
Well, it's just that before, even when I left the time that I left before, it was also the same day. And then management, supervisor at the PDC office, when I asked him whether it would be okay for me to leave that same day or whether they needed an advance notice, he told me that I didn't need one, and I can name that supervisor.
And who was that?
Madam. And that was when I resigned in 2018. So he said that there wasn't a need for one. He won't play negatively against me.
So if I'm hearing you right, based on what happened in 2018, you decided that's what should dictate your behavior in 2020.
I wasn't informed that there was a difference in rules and procedures.
Okay. I believe you've also alleged that the agency wouldn't provide you with the performance plan, right?
Yes.
But you don't know whether or not Mr. Martin ever forwarded those questions to HR. Is that right?
Would you repeat that question, please?
You don't. Do you know whether Mr. Martin ever forwarded your questions to HR or to the personnel department?
I believe that during discovery, the agency provided an email that Mr. Martin sent, I think it was on Sunday or Monday, to HR, asking if they had seen my resignation email.
Okay.
But for the whole year, when I called several people in HR, and when I called Mr. Martin and emailed everybody, nobody gave me an answer.
Okay. You've also alleged, haven't you, that the agency's post-employment restrictions retaliated against you? All right.
Yes.
Let's look at the same tab 23. It's going to be pages 139 through 148.
Yes.
Okay. So you're on page 139?
Yes.
All right, I'd like you to read, it's the first line of it, and it starts with to. Please read to and who the to is to, please.
All SBA employees.
Okay, that says all SBA employees. And at the time you received this, immediately prior to receiving this, you had been an SBA employee, correct?
Yes.
And that line then doesn't exclude anyone from anyone who's an SBA employee, does it?
That line specifically says all, so...
So that would have included you, correct?
That would have included me normally, yes.
Okay. Now, I think we spoke earlier, and acknowledge that you're in Cameroon and looking to start an NGO or a nonprofit?
Yes.
Okay, that's only been for a few months, hasn't it?
Yes.
But you also testified earlier today, didn't you, that you only became aware that you might be protected by the Whistleblower Protection Act in about July or August of this year?
Yes. Yes. That was yes. Mm-hmm.
Even though we saw earlier that you had passed whistleblower training in June of 2020.
Yes, and that's why I said that I didn't recall that training. I guess I must have just watched it, just thinking that it was something that happened to other people, so I didn't try to remember it, and so I didn't store that information. Otherwise, if I knew about, if I remember that, if I knew about the rights of whistleblowers, I would have probably kept my file, my documents before leaving. I would have given them all to my supervisors when I left, because I would have had proof of certain things that happened.
And as we sit here today, you're not able to name anyone specifically that the agency treated more favorably than you, right?
I tried to obtain that information during discovery. I wasn't able to, but the information that I have right now is that I have never heard of, I've known of many people that have worked at the SBA in 2017 and 2018, and that never mentioned anything like this. And also when I left the SBA in 2018, I did not receive this document, this post-employment restriction document.
And so is it your testimony that because you didn't get this document in 2018, it was somehow inappropriate to give it to you in 2020?
It is my testimony that because I didn't receive it in 2018, and I've never heard of anybody that received it, that this document is probably being given to people depending on whether the agency actually wants to restrict their post-employment activities or not.
Isn't it possible that you just forgot you received it in 2018?
No, because I kept those emails because, for example, I have the performance ratings, the email conversations that I had with HR after I left the SBA in 2018. I still had it in my emails, and I was able to use that to submit to the EO office and to pull up my performance ratings and things like that. So if I had received something like that, it would have been in those emails, but it wasn't.
And did I hear you correctly that you had talked to other people who had not received these same restrictions?
Yeah, yes. Some people, nobody ever mentioned it because I believe that restrictions like saying that one cannot work for anybody that has received SBA loans for, I think it says a year or two. That is something significant enough that people would be talking about it if they had received anything like that. Because that would significantly impact how things go after they leave the SBA.
Who are the people that you talked to?
No, what I'm saying is that I know a lot of people that worked at the SBA in 2017 and 2018 that never mentioned it.
And they were who?
There were people, attorneys that worked at the SBA.
Do they have names?
They do have names, but I don't wanna try and remember them now.
Did you actually ask those individuals, whoever they might have been, if they got this document?
I asked at least one person.
Who was the one person then?
She still works at the SBA now, and her name is her name escapes me.
Or you'll have to spell that. I couldn't.
Moelle. Her last name is Moelle. I forgot her first name. But she, for example, did not answer my question. So I don't know whether she received it or not. But what I'm saying is that generally, people did not, never mentioned it to me.
I believe I'm confused. You said she never answered the question?
Yes, I asked her whether she received it. She never told me.
Okay, very well. I'm just looking through my notes, and ma'am, I think I've asked you all the questions I had. We got through that quicker than I expected, so thank you. So, Judge, I believe I'm done, and I believe it now goes back to Ms. Kouemo.
All right, it does indeed. So, Ms. Kouemo, do you have any redirects that you'd like to offer to clarify questions you were asked by Mr. Powell?
Yes, Judge. I would like to speak on some things that some questions that you asked me. I'd like to clarify some things.
You may.
Okay, thank you. So the agency asked me, Mr. Howard, asked me whether the rule change regarding the EIDL loans was whether I knew that it was retroactive. I believe that's what he said, and I would like to say that I did not believe the rule retroactive per se, but I believe that going forward that the applicants that qualified for the loans had to know about the rule change, so that if they had applied before, that they could reapply and have their loans approved if they met all of the criteria. And also regarding the SOP, I believe that the SOP was violated by the fact that those applicants did not have that qualified under the rule change, did not have a valid opportunity to reapply, and that even in reconsideration, during the reconsideration process, that their applications were not approved under the rule change. When I believe the agency should have taken that the fact that it had changed the rules itself into consideration. And regarding whether I made any direct disclosure to management, I would like to reiterate that I did make indirect disclosures to management regarding the changes to the EIDL laws by making the disclosures to my team lead, and by doing so in writing, for example, even through my phone calls, which we believe were being monitored for performance review. And whether Mrs. Powell told anyone else, or whether anyone told anyone else, I don't have that information, but I believe that such personal information will have probably circulated amongst management. Regarding my sick leave, when I was told to call Mrs. Rivera, whether Mrs. Rivera didn't tell me specifically when to call her, but the fact that she contacted me more than once, more than twice. So my team lead, during the same day when she knew that I was out sick, and within a few hours and sometimes minutes, indicated that she wanted a quick response. So because she was my supervisor, I didn't want to be guessing as to whether that quick response would come the same day or the next day. So I went ahead and contacted her the same day just to make sure. And as far as the interest in knowing whether she had any interest in knowing whether I would be at work, Mrs. Rivera did had an interest in knowing who would be at work, but because she knew that I was sick, recovering from an illness is not something that is predictable. So as a manager, she should know that. So there wasn't any way I could predict whether I would be able for sure to be at work the next day, even though I had indicated that I would probably be there. And also, it's true that we were going through a pandemic, and we still are. And she might have had an interest in knowing whether I had COVID-19 or not, but that information could have waited later in the day when I said that I would call her or contact her after I left the emergency room, or it could have waited even better the next day when hopefully I will feel better, or hopefully I will be at work. Just because if I was really sick, then she will have known about it the next day anyway. And even if her motive was, say, I had died, say, of COVID-19, somebody, the SBA had my emergency contacts information, and she could have had access to that information that way. Then want to see about the rule that Mr. Howell pointed out that I mentioned in my brief, CFR 2009, Title 5, Number 1, and I didn't write down the rest. When it says that the management can contact somebody that is sick after less than 3 days when the agency determines it's necessary. In my case, it wasn't necessary to do so because there wasn't anything urgent that the agency needed so badly that they had to contact me on that specific day when he knew that, when my supervisors knew that I was at the emergency room, and when my well-being should have been the priority. I wasn't the only person on the triage assigned to the funding triage team, meaning the data entry team, but that doesn't mean that I wasn't retaliated against, just because I was part of a group of people. And I believe that I was still being retaliated against. As far as the annual leave, there was a customary during the course of this process, and even as I submitted the documents before, there was a custom at the SBA that annual leave could be approved after the fact. For instance, in 2017 and 2018, 3 separate times at least, I had absences of 2 absences of roughly 15 minutes, and 1 absence of roughly an hour. And all times, my supervisor, who was Mrs. Rivera, approved those requests after the fact. Actually the same day, without requesting any documentation, without requesting any more explanations than what I said, meaning that I was just late. And for the 1 hour absence, I just had that something had come up. So it's not that different from saying that I had a personal emergency. So there wasn't any indication that anything would be different this time around. And so that's why the AWOL being implemented at the end of everything, of the whole time period, was a surprise to me. And even regarding the phone calls, as I mentioned before, I started the phone calls specifically to talk about reconsideration for EIB alone, which is something that touched directly with my work duties. And if the conversation veered after 15 minutes or so into something else, because I had planned on spending only less than 15 minutes. Actually, my email appointment with my colleague, I had only asked for a few minutes, so for 5 minutes or so. So I did not plan on being on the phone for an hour. And the only reason why I stayed on the phone for that long is because I believe that it was still acceptable because we were talking about SBA matters. So based on my time before the agency, we had phone calls, not with other, I had phone calls, not maybe not with other officers, but with other people in the office about general SBA matters without necessarily have to request time off. And as I was completing, as I was reading the SOP, that reading the SOP wasn't something that was required of me. At no time had any one of my supervisors or even team lead indicated that it was mandatory for me to read the SOP. But I took it upon myself to do so just to learn about what was going on at the agency. And also, many of the trainings that I completed were not required at all. They were completely optional, and I picked them based on whether I thought they would be interesting. And I was never told I had to request annual leave, or that I had to I would become AWOL if I did that, because some of them didn't touch at all on ODA matters or PDC matters. Some of them touch on management, for example, or general SBA loans, for example, which is really close to what I discussed with the other colleagues at the other office. Regarding my personal emergency, like I said before, I did not believe that it was necessary for me to elaborate on what was a personal emergency. It was a personal emergency to me because I had been working on the data entry team for several weeks, and by that time, I believe that if I had been hired to work as an attorney, my work duties didn't indicate at all that I would end up in the entry for a significant amount of time. And I believe that if that was all that the SBA believed that they could get out of me, then maybe it was time to look for a job somewhere else. And as I said during my deposition, I indicated that it was an emergency to me because it was an emergency for me to leave the data entry task. So that's why it was an emergency. And then the job, the deadline to apply for that job was coming up. And I didn't want to miss. I wanted to maximize the opportunity that I had in front of me. And the job was within the federal government still. So that's why I took some time off to apply. Regarding the Form 45 or 60, the SBA has now adopted a version of the form. Now, the ODA office now requires that applicants submit a version of that form that does protect PII data. Therefore, by doing that, it acknowledges that it's a better way to go about. It's a better version. It's a better. It acknowledges that when it required the March version of the form, it wasn't really the best decision that it could have taken at the time. So, it sort of acknowledges that by requiring now that people provide a version of the form that protects P2 data, and also during the few days that the ODA office or the PDC office required that we request the March 4506T, the March version of the form 4506T. The SBA had issued warnings to applicants about about phishing emails related to the EIDL, specifically for the EIDL loans. So the SBA had a duty to comply with, basically to follow the leadership, the higher level leadership, and request a version of the form that better handled privately identifiable information, especially when months before in March or April 2020, the ODA office, those specific loans had a cyber attack. There was a cyber attack that shut down our office for almost a week. So based on that information, management should have made a better decision. And I believe that I've gone through my notes, and that's it for now.
Okay, thank you, Ms. Kouemo. So does that conclude your redirect testimony?
Yes.
All right, so Mr. Howell, do you have any recross?
I believe just a very few. Ms. Kouemo, I believe you were just testifying about phishing emails and how that led to your belief in the disclosure related to the IRS form, correct?
No, it didn't. Yes, the phishing emails. Yes, the emails from outside parties that were trying to infiltrate. Yes, the system. Yes.
What is it that a phishing email had to do with an IRS form, and which version should be used?
The phishing email, because we received those phishing emails to our SBA, emails, and also I believe we had at least one questionable attempt into our personal emails. But I believe that by people trying to fish into the SBA our work emails, because we received that information, we received the documents, the forms that the employees, that the applicants will provide, usually it's often by email. Then if somebody, for example, was able to reach through the SBA database, they will have access to that information because we received them sometimes by email. And those requests specifically were made by email. So even if they didn't have access to the specific form, say if the applicant submitted the form in a different way, those emails will have access to the applicant's email. I mean, those phishing people will have access to the applicant's email, and by doing that, will have access to the documents that they could be handling in those emails, including search forms.
Is it that you believe was going to access the SBA's emails? I'm not sure I follow.
Outside parties, malicious people.
And when, if ever, did you tell a supervisor that you believed the form, the version of the form would lead to phishing?
No, I did not believe that a version of the form would lead to phishing, but I believe that a version of the form exposed people's data to phishing scam, to people that could, to scammers, basically. Yes, that's what I mean.
And I believe you testified that you believe your communications were monitored by management.
Yes.
But you don't have any knowledge that actually happened, do you?
It specifically states so in my performance plan. So if management, if my supervisors actually perform their duties, they will have to have access to my emails and phone records. Because those performance plans specifically say, I'm sorry, the performance plan that applied to attorneys at the PDC specifically said that supervisors had to, that attorneys' work will be reviewed on things like their communication, written and verbal, and so forth, with the customers and with and internally.
Okay, but as we sit here, you don't know of any specific manager who listened in on a phone conversation you had, do you?
Well, I wouldn't know what, when they go behind the scenes to do those things, because I wasn't part of the management. And I did request an information during discovery, I wasn't able to obtain it.
So then you have no evidence that it happened, isn't that true?
I have evidence of my performance plan, of my performance rating, and then I had evidence of the same type of, in 2018 when I left, and I received a review of my work. That included a review of my email communications and phone communications with everybody.
I think that's all my questions. Thank you, Ms.
All right, okay, thank you. All right, I believe that concludes then Ms. Kouemo's testimony. So we will move on after a lunch break to the testimony of the next witness. And Ms. Kouemo, is that Letitia Parham, is that correct?
Yes, it is.
Okay, thank you. All right, so again, we'll take a 30-minute lunch break. When we reconvene, Mr. Howell, if you will please have the next witness available to testify. Let's go off the record.
We are off the record at 12:01 p.m. We are back on the record at 12:36 p.m.
All right, we're back on the record with the next witness, Letitia Parham. Somehow during the break, my video camera went off, and so I am no longer appearing on the screen visible to the parties. We've clarified that everybody can still hear me clearly, but for the time being, there's no video service showing my face. The parties have indicated they have no objection to proceeding in that manner. Is that correct, Ms. Kouemo?
Yes, it is.
And Mr. Howell?
That's correct.
All right, so we're going to proceed with the testimony of Ms. Parham. Ms. Parham, before you testify, I do need to swear you in. So if you would please raise your right hand. Do you swear or affirm the testimony you are about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am. You may lower your hand. Thank you. So, Ms. Parham, you have been asked to provide testimony in the appeal of Sylviane Kouemo versus the Small Business Administration. If an objection is raised to a question that you are asked during your testimony, please wait for me to rule on the objection, and then I will let you know whether or not to proceed with the response. In addition, please be sure to answer all the questions orally and keep your voice raised so that we can all hear your testimony and accurately capture it for the record. You're going to be asked questions in a couple of rounds. First, Ms. Kouemo is going to ask you questions. Then the agency will have an opportunity to ask you questions through their representative, Ms. Heiser. Then Ms. Kouemo will get a second opportunity, and then the agency will have a second opportunity, and then you'll be released from testifying here today. Before I turn it over to Ms. Kouemo, would you please state and then spell your full name?
Letitia Parham, LATISHA PARHAM.
Are you currently employed by the Small Business Administration?
I am.
In what position?
Supervisory Attorney Advisor.
How long have you been a Supervisory Attorney Advisor for the SBA?
Since August of 2021.
And did you work for the SBA prior to August 2021?
Yes.
In what position?
I worked as a attorney advisor prior to supervisory attorney advisor, and prior to that as a paralegal.
Approximately what dates did you serve in the attorney advisor position?
From 2013 until August of 2021.
All right, Ms. Kouemo, you may proceed.
Thank you, Judge. Before I do proceed, should I call you Mrs. Brown or Letitia like I used to? Or I'm not sure if there are rules about such things before the board.
I'm open.
There are no specific requirements, Ms. Kouemo. Generally, we're more formal than less formal, so perhaps Ms. Parham might be more typical.
Okay, so I'm going to call you Miss it's just going to be very difficult because I used to call you Letitia. But Ms. Parham, you say that you worked at the SBA from 2013 to 2021 as an attorney at Banjo. You were my team lead. I want to ask you to confirm that you were a team lead before you became a supervisor, right?
Yes, I was a team lead before I became a supervisory attorney. I rotated in team.
Okay. When did you start working as a team lead?